Nazi Germany and the totalitarian state that Hitler ran was only possible because years prior to him taking power, the Supreme Court of Germany passed a law that supported and embraced purely positive law. Okay, so what does that mean? So there's a long tradition that natural law would always inform and guide positive law, and there's just different debates of how that plays out. And sometimes positive law was mistakenly like made into civil law. Like it becomes a problem when you begin to want to enforce morality through law. It's always not a good thing, because morality has to be a virtue. You can't, especially with democracy, you have to encourage time for citizens to be virtuous. You can't make up for that. Democracy does not work unless we as individual citizens be virtuous. And if you try and make up for that by law, there's no virtue coming from that.
Is there an example of that happening? Like an example of that, like you said, like people trying to enforce like moral law, like in the civil law?
Well, like prohibition is usually one they point to in the United States when they try to say, okay, no more. We're going to go so far, like you can't drink anymore, and go so far. And so you have to be careful how you navigate it, right? And so they did that, and there's sometimes in trying to put forth a law that flows from a certain morality, it can begin to open up to a greater evil. In that case, organized crime at the time just spiked. And so you have to really begin to realize that sometimes a particular law can cause more damage at one point. So we have to navigate through that. However, the other extreme of that is this positive law thing. Okay, well, if we just don't need, nothing needs to guide us, we'll just get together and choose. As long as the legislature says so, then that's fine. And that's what the Supreme Court in Germany did in the 1930s. They basically essentially said the law becomes a law because the lawmakers say so. And it went through the proper process to get that. And once that happens, done. Right? And so this was the standard, and then you saw the effects of it in World War II by the lack of dignity of human person, natural rights, and it all really came out where the world consciousness shifted in the Nuremberg trials after the war. Have you heard of that?
The what?
The Nuremberg trials?
No.
Are you familiar with World War II, your generation?
Yeah.
Yeah, you got that one. You had the Nuremberg trials, you can even watch a movie how it played out. Because the winners of the World War II, there was a winner, the UK, US, and then Russia. Okay, so the three of them got together. Russia wanted to just kill off everyone who did these war crimes. US and UK said, no, everyone doesn't deserve a just trial. So they had an international court, and they had this trial in Nuremberg in Germany, and they had these war criminals tried. But they were able to get their own lawyer, make the defense. And one of the leaders, the highest ranking leader, gave us this defense. And his defense was as such, and it was a very shrewd defense that he gave, that he pointed out that domestic law, law of Germany, is not under the standards of international law, because it's a sovereign state. So the laws of the other nations can't be put on Germany. And the local laws were all made legally. So he appealed to the Supreme Court of Germany. The legislators make the law, and therefore he was following the law. Therefore, he had no fault. And so this is what happens: purely positive law or civil law that is made only by legislators. When you begin to just do that law by only consensus, and you remove the inherent dignity of the human person, all of a sudden law can begin to work against human rights, human dignity. This is what St. Augustine says: is when civil law or positive law contradicts natural law, it becomes unjust law, no law at all. And we as citizens, as Christians, must know how to disobey, right? So we must disobey unjust laws. And we should teach next generations the proper standards of disobeying, not because you didn't get what we wanted, so we burn cars on the streets. No, that's not where there's something fundamentally shifted that we must know about. And I think this is something right for Belize is very much pointed. Well, let me finish the Nuremberg trial, right? So I'll come back how it applies to Belize. So he made this defense, and he was right in his defense, though. He logically defense. And the four international judges responded to by going back to natural law, although they didn't use that term. They talked about crimes against humanity. There's some things so evil, you just know it's wrong.
Yeah.
Because everything in Nazi Germany, the killing of Jews, the ghettos, the starvations, everything that they did was legal. They didn't break one civil law, right? And this was what happens when we no longer have natural law and the inherent dignity of the person informing our laws in society. Eventually, it goes very sour, and that's a lesson from the last century. From that moment, though, and this is where it gets unique for Caribbean states, that sent the response of the international judges that appealing to this law written in our human nature, or these crimes against humanity, led to a renewed consciousness of human rights based on inherent dignity. And so the UN that formed after, right, the dialogue, even people start saying, well, if individuals have these rights, that means the Crown's authority is not absolute. So the Crown of England does not have absolute authority over everyone. It's limited too. So now the inherent dignity of the person, which in the human rights that follows, limits the Crown's authority, but even limits popular piety. It's not just like have everyone vote. You hear that a lot of beliefs now. Oh, just let the people vote. And even popular piety has to be guided, because the popular piety could vote. You could become a mob. So that must be guided by certain principles that are unchanging. And this was the great wisdom of last century that led to our Constitution. When you say that we acknowledge the principles of the supremacy of God, and then the position of the family, right? These equal and inalienable rights that are this language that came out is rooted in this lesson from the last century. And which goes back to an age-old understanding that natural law must inform civil law. You must have dialogue and debate, because it has to be something living of the people. But there's always a guide of our inherent human dignity from which our human rights fall. So that's a lesson of human history. That was put in your Constitution. Now here we are, years later, your generation, if you forget the lessons of that history, what happens when, say, we need rights-based approaches to law, right? And so these organizations now have UN consensus, so you have rights-based approaches so we want to write certain laws in. But these rights that they're saying that they want to base your laws in, what happens if they're not rooted in the inherent dignity of a person? So all of a sudden I have a right, even though I'm a biological man, to be a woman. And that means that all of you have to change and how you treat me. Right? You begin to lose the order of things, right? Justice, you treat equal things equally and you treat unequal things unequally. But when you start treating equal things equally, or unequal beings equally, you begin to confuse justice. And so this is a lesson that is now very present now in the way that many laws are being present in police right now. And the young people, we have to return to this, because even certain movements in international courts that influence some laws that are being written, not all these laws that are being proposed are rooted in natural law and the inherent dignity of the human person. It gets even more confusing, because in court they talk about human dignity. They drop that word inherent. So my human dignity is because I can express myself. Not my human dignity because of who I am. And we must insist, from the lessons learned from last century, and from the wisdom of the Father of the Nation, that dignity is inherent. That's what's being understood there. And so, these are certain distinctions that we have to always ask. How does natural law inform civil law? Another one is, in rights-based approaches, do we protect pre-political rights or natural rights that exist in the person? So we had rights before 1981. Not all our rights come from written law. And it's important that we insist that remains. But many rights-based approaches, advocacy movements, are actually only consensus-based from those who have power. And they will also they deny or weaken pre-political rights in a subtle way. So that's something else that your generation, that you all has to understand and begin to defend right now, currently. Because if it shifts, you begin to lose your footing on some things,